Okay, we are now live on YouTube. So welcome to this morning's session of the Kansas Court of Appeals. Another Zoom session still in our COVID world. I think we'll probably be continuing those through September. I'm Chief Judge Karen Arnoldberger. I'll be presiding over this panel, which simply means I'll be timekeeping. To your left, as you look at this screen, is Judge Gordon Atchison. I'm the most senior judge on the panel today. And to my right is Judge J.C. Hurst, the least senior member of our court. I will let you know that Judge Hurst's video, she's been having a problem with it just stopping every now and then, and she has to restart it. But when that happens, she can still hear everything. So if you see her black out for just a second and then come back on, that's what's going on. With that, I will let you know that I do know we threw a little curveball at you last week as far as addressing the issue of jurisdiction. So with that in mind, I'm going to give you each 20 minutes to argue instead of 15, so you'll be sure and have time to address the jurisdiction issue. We have read the facts of your case. We're very well aware of them. So please don't take a lot of time going over, although this is a pretty fact-intensive case. I understand that, but we are familiar with the facts. With that, I would ask Mr. Nelson, or no, Mr. Odle, whether you wish to reserve any time for rebuttal.
I would like to reserve 5 minutes, Your Honor.
5 minutes? Okay. Let's see. You'll find that my one job, I'm not very good at it. So we'll see how this goes. All right, if there aren't any questions or anything before we begin, we'll go ahead and get started. Mr. Odle, and am I pronouncing that right? Is it Odle
yes.
or Odell?
Yes.
Odle.
Yes.
Okay. Thank you.
May it please the court, my name is Bill Odle, and I represent the petitioner appellant, in this case, Richard McAllister. As Judge Arnoldberger pointed out, you're familiar with the facts of the case. You're familiar with.
I'm going to stop you for just a second. Could you be a little louder, or maybe talk?
Sure. No, let me adjust my mic.
I've got my volume turned all the way up, and I'm still having a little bit of trouble hearing you, and it may be from my end. But thank you.
Sure. Is that better?
Yes, that's much better.
Okay. Sorry, I've got a fairly booming voice. People tell me sometimes too, so I never know where to put this. And this is actually my first oral argument on Zoom. So I've done a bunch of mediations, done all sorts of other stuff, but this is my first oral argument. So I apologize in advance if I have any technical issues or anything. And hopefully I've got my labs. I'm working from home remotely, so I've got my labs stashed away, so hopefully they won't go nuts and bark at something. As to the jurisdictional, yes, exactly.
Okay. All right.
As to the jurisdictional issue, I would first point out that the Bates v. Berry case, which the court cited in its show cause order, involved and the Whitaker case before that is cited in Bates v. Berry. All involved cases which there were proceedings still pending in the district court. And in this case, if the court were to reverse, or rather affirm, there's nothing more to do. There's no personal jurisdiction. There's nothing, no further proceedings to even occur in the district court. So for that reason, I think the Bates case is distinguishable. And if you look at the federal rules, which are usually held by Kansas courts to be instructive to the analog Kansas rules, where there's a void judgment that is set aside, that is an appealable final order. And if you look at recent case, Gold v. Tucker, 2000 or 2021 Westlaw 683461 out of the Southern District of Texas, that's what they hold. Same to the same point.
I'm sorry, would you say that site again, Mr. Odle?
Sure.
2021 Westlaw
683461.
Okay, thank you.
It's a Southern District of Texas, 2021. Goal is GOEL versus Tucker. In the same vein, this court has entertained appeals from motions to set aside judgments in divorce cases. And I would point the court toward In Re Matter of Lane, Laine. That's 34 Can Out Second 519. And there are several other cases I can provide to the court in a supplemental memorandum where the court has entertained appeals from grants of motions to either deny or grant a motion to set aside a judgment in a dissolution case, which is exactly what happened here.
This wasn't a motion to set aside the divorce. It was a motion to set aside the default judgment, from what I can tell. Is that right?
Right. Well, it's Mr. Nelson's motion was not clear in terms of which subsection of Rule 60B they were relying on, but I believe it's to set aside the judgment or the dissolution decree as void, which would be what B4, I think.
Right,
So,
but the court never entered an order dismissing the case. It set aside the default judgment, which then presumably something happens after that in the case. And not to suggest I'm an expert in this area of the law, because I'm not. I presume Mr. Nelson would then file a motion to dismiss based on lack of personal jurisdiction, which is probably tantamount to what's already been decided. And then you file a response if you want, and the district court then issues an order dismissing the case for lack of personal jurisdiction. That hasn't happened yet. And I think when we're dealing with the court's jurisdiction, it's not just a matter of form over substance here. And I think that's what we were trying to get at, is that there is no final order here. There's another step that has to be taken, it seems like to me.
Yeah, Judge, I'm not sure what that step would be. Once
it will be a dismissal of the case. Right now, what you have is an order setting aside the default judgment. So there's no judgment in the case. The case is still open in that sense.
In that sense, I would agree. But I would also point out that, for example, in the Bates case, the trial court set aside the judgment and granted the defendant leave to file an answer. So it was clear that there are further proceedings to be had. Here, if there's no personal jurisdiction whatsoever, which is what the trial court found, it would seem...
Well, it did find that it had NREM jurisdiction over any property they had in Kansas, and we don't know from we know some allegations of property that I think there was some allegations of a bank account in Kansas, and I don't know about any other real property. I don't think there was any evidence of it, but this is at the very preliminary stages. There's been no discovery or anything in the rest of the case. So, he did say he continues to have NREM jurisdiction over any property held in Kansas, I think, didn't he?
I don't believe the trial court reached that issue at all. I think that my recollection is that the court found that there just was no personal jurisdiction. Obviously, the law is well settled that the court would have jurisdiction to grant just a dissolution of the divorce. And if there's no personal jurisdiction, there would not be the court would not have the authority to divide the marital estate, for example, or award maintenance. But in this case, I think the court did not reach those issues. Pardon me.
Right. Mm-hmm.
So it seems to me that if this court were to affirm the district court, I don't know what proceedings and pursuant to which rule there would be any need for additional proceedings. The court has already decided there's no personal jurisdiction. So it would seem to me Mr. Nelson wouldn't need to file another motion to dismiss the case because the judgment is void. It's set aside. A void judgment is as if it never happened. It was never entered. So
but you can have a void judgment in a ongoing case, there can be some and if the judgment was void, the judgment that was entered was void, does not necessarily mean the whole case is gone.
I think it might, Judge, if it's a judgment that is final.
Right.
It kind of boils down to that. And we think that the court entered a judgment that leaves nothing else to be decided by the district court at this point. It's just either there's personal jurisdiction consistent with due process and minimum contacts, or there's not. And the court could have ordered just granted in part a dissolution, but that wasn't the relief that my client sought in the district court, and that's not what the judge, the trial court held. So in that respect, there is nothing further to adjudicate in the trial court.
In filing the case, did you obtain service by publication in addition to personal service under the Hague Convention?
My partner, Susan Galamba, handled that part of the case. Obviously it's been briefed, and although the issue was not reached by the trial court, service was made under the Hague Convention. We believe completely consistent.
Well, I understand. I got that, and I understand that's a disputed issue. My question, and if you don't know, that's fine. We can figure it out, but
I don't know, Judge. I do not believe so, and I don't know that there's any reflection in the record that was done, that service by publication was done. But I don't want to completely commit to that because I'm not.
No. The record is what it is. If there was service by publication or not, I just don't remember.
I think the partner put in the record all of the stuff that was complied with regard to the Hague Convention. I think that's all a matter of record, and it doesn't seem like there's kind of any more fight over that, but I don't know, maybe there is.
Well, the trial court never did reach the issue.
Right, it didn't have to, right.
And it is not an uncomplicated, admittedly, not an uncomplicated legal issue to deal with. But I think, we fully complied with, the requirements. You might want to go ahead and get into your underlying argument. Oh, sure.
Okay, since you're running out of time.
Sure. Well, I think this really kind of boils down to which subsection of the long-arm statute applies and whether or not the exercise of personal jurisdiction over the appellee is consistent with due process and whether or not she has minimum contacts. And what the trial court held is not that she did not have sufficient minimum contacts for purposes of either the long-arm statute or subsection, I guess it's now L, which is sort of the catch-all under the long-arm statute. The judge didn't hold that. The trial court held that the contacts that the appellee had were stale, essentially. They were like, the parties were married, as you know, in like 2001 until my clients transferred to Switzerland in 2007. And the trial court held that those were simply, stale contacts, too remote in time, not that they were not sufficient for purposes of due process. So the problem with that, as we cite in our brief, is that issue or that consideration only factors in to the question of whether or not there's general jurisdiction, not subject matter, or not personal jurisdiction or specific jurisdiction, where Kansas is like most states, is a one-act state for purposes of, like, for example, contracts, making of contracts. And no Kansas court has ever held that a marital contract is not a contract for purposes of the long-arm statute. They just haven't. And we think that, it's undisputed as a matter of law that multiple prongs of the long-arm statute can apply. So, for example, making a marital contract with the intent of, establishing a marital domicile in Kansas, we think, fits well within, the contract prong of the long-arm statute.
Excuse me, counsel. You said for the intent of maintaining a marital domicile in Kansas. It's my understanding that they did not maintain a marital domicile for most of their marriage in Kansas?
Well, I believe they resided in Kansas from the period of 2001 to 2007, when Mr. McAllister was transferred to Switzerland, which was a job transfer. He didn't, was not voluntary. The intent was, and in fact, the record has within it the notice from his employer, Swiss Re, that it was going to be a temporary, or he understood it was going to be a temporary transfer.
Did they maintain the residence in Kansas upon the transfer?
I do not believe so.
Okay.
I think I believe, I seem to recall that the transfer was supposed to be for a period of like 2 years. So I wouldn't expect that my client would continue to pay a mortgage on their home that they own together in Overland Park for the 2-year period. And it turned out to be a longer period, obviously, in part because my client had a stroke and was unable to return to Kansas or the U.S. Because of health reasons, and that I think alone signifies that there was really never any intent on his part to abandon his domicile in Kansas, or he always intended to return, and in fact he did return.
Can you tell me some of the other items they maintained in Kansas that would demonstrate an intent to maintain a domicile?
Sure. The appellee became a citizen of the U.S. in Kansas. They owned a home together in Kansas, purchased, I think, in 2001. She lived and worked in Kansas for that whole period. She never lived in any other state but Kansas. So if there's any place there's jurisdiction within the U.S. for a dissolution proceeding, it's got to be Kansas. There's no other alternative. They held joint bank accounts in Kansas. The only connection that appellee ever had with the U.S. is in Kansas, and she would come back and visit after. I think they had moved to Switzerland. So I do believe that there is sufficient minimum contact for purposes of the due process clause to, there's no other contract. If we enter into a contract to, buy a widget in Kansas, that alone gives you a basis on a single act principle to base personal jurisdiction on. There could be no more permanent, no more willful availment of Kansas law than to get married under Kansas law, which is by statute a contract. And I don't know how the court can avoid reconciling the fact that the statutes provide explicitly that marriage is a civil contract, yet not apply that principle in the context of 6308B. It just, and again, I don't believe there are any Kansas cases that I'm aware of which have held that under the similar circumstances that there's no personal jurisdiction where the parties are married in Kansas. I think it's very important to note that in all of the cases cited by appellee, including Guy v. Guy, the Wisnett case, those all involved marriages that were entered into in other states, not in Kansas. And so there was no contract and no basis to even argue that subsection E applied in those contracts of marriage. So this is different because it's undisputed the parties were married in Kansas and lived in Kansas and established a home here and only left because my client was transferred by his job. So it seems to me that again, the remoteness of time of those contacts, which is the basis of the trial court's ruling, under existing law, federal law, the analog rules, it's irrelevant to the determination of specific jurisdiction. It only is a consideration when the court is attempting to discern whether or not there's general jurisdiction, which isn't alleged here and isn't the case here. We're only alleging specific jurisdiction as against the appellee. Pardon me.
Okay, you are done with your primary section. You've still got your 5 minutes in rebuttal.
Thank you, Judge.
Okay. Mr. Nelson, what say you?
Thank you, Your Honor. May it please the court, with regard to the first issue on the court's show cause order, this is not a final judgment. Judge Hauber did set aside the default judgment entered on request by the petitioner. The court, actually, we had filed a motion to set aside the entire matter, including the divorce. We argued before the district court that the court had no jurisdiction either to divide property or in fact to grant a divorce. Judge Hauber decided that he could grant a divorce, but set aside the default decree, so he did not grant a divorce. Plaintiff or petitioner then filed this appeal, but there's still a divorce waiting. So the matter is not final. Petitioner could have gone forward and obtained a divorce, at which time a final judgment would enter, and at which time the petitioner then could file this appeal. But not having obtained a divorce, there is no final judgment. With regard, and it's as simple as that. With regard to the other matters, essentially what the petitioner is relying on is solely that these parties married in the state of Kansas. I won't belabor the facts of this case, but as Mr. Odle indicated, the only state that my client was at while married was Kansas. She came here from the Ukraine, was married in Kansas. The parties did reside in Kansas and then left, and for 10 years after that, lived in Switzerland, and my client continues to live in Switzerland.
If I could interrupt you for just a second, Mr. Nelson. Judge Hauber in this case kind of perfunctorily said that the marriage contract, that the long arm statute doesn't, that those exceptions don't, or those statement lists in the statute don't apply, and that a marital contract, a marriage is not a contract. What is your best case that involves a Kansas marriage? Because all the cases cited, your opposing counsel is correct. All the cases cited by the court were cases in which the marriage took place in a different state. Do you have any cases to give us that say that that show that there was no jurisdiction when the marriage occurred in the state of Kansas?
I do not have a Kansas case. However, Colco versus Superior Court speaks directly to that. In the Colco case, and I believe the court probably has that citation, but that's the US.
Did you put it in your brief?
I don't know if it's there or not, but it's the United States Supreme Court case.
Okay.
436 US 84, 1978.
Okay.
And in that case, the parties had married in California and then went elsewhere, lived elsewhere, and ended up separating while they were in New York State. The wife then sued in California. The US Supreme Court in passing noted that the mere fact that the parties had married in California did not give California jurisdiction over the out-of-state party. One of the things in passing, or one of the things that Mr. Odle indicated in his reply was that somehow we are arguing for strict construction of the statute. That is not at all what we are arguing. What we discussed was liberal construction, and essentially that holds true in this case. It's liberal construction, regardless of the fact that that section L was put into the statute in 2010. That doesn't do away with liberal construction of the statute. It also doesn't mean that you ignore the statute or ignore the terms of the statute. That is not strict construction. You look at what the statute says. You look at the plain language of the statute to see what the legislature intended. And also, as Mr. Odell indicated in his reply brief, you do use those specific provisions as a guide to see whether Kansas can have jurisdiction in the particular matter. Again, regarding the Colco case, it says that merely being married in the state does not grant the state sufficient personal jurisdiction over the non-state or the out-of-state party. So with regard to a civil contract, we argue that marriage, even though it's designated as a civil contract, is not the kind of contract that the legislature intended. It is a relationship, and as Judge Haber indicated, the particular matter in this doesn't have to do with a damages action regarding the marriage. It's a divorce, and it is seeking to set aside the property that the parties own. I will note that none of the property that the parties own or that was divided in the default decree was located in the state of Kansas. There's real estate that the parties owned, and that is in Switzerland. There were other items that the parties owned. The default decree indicates which are in Switzerland. With regard to bank accounts don't have a situs. They don't have a specific location. Bank accounts aren't money in the bank in the place where the parties bank. It's not like real property. It's not like personal or household property. It doesn't have a place. It is where the party is. And basically the context in this case, as Judge Haber indicated, the parties had been outside of the state of Kansas for over 10 years. Mr. McAllister had filed a separate maintenance action in Switzerland, merely because it is convenient for Mr. McAllister to file a divorce and obtain a property division in Kansas doesn't grant the power of the court for his convenience under the Due Process Clause. A number of US Supreme Court cases and Kansas Supreme Court cases and Court of Appeals cases indicate that you have to look at the context of the defendant, the respondent, in determining whether there are minimum and sufficient contacts to satisfy due process. That basically is my argument. I will leave the rest of my brief for the court's consideration.
I'm going to ask you, because I just looked up this Colco case that you talked about, the Superior Court of California, where the couple was married in California, but it looks like the only connection to California prior to the divorce was he was on duty, active duty, and he had a stopover for 3 days in Kansas, and they got married, and they never lived together in Kansas as husband and wife, or I'm sorry, California. Never lived together in California as husband or wife. They just kind of stopped into Kansas, got married, and left. Don't you think there's more here than that? The parties lived together in Kansas for almost 5 years. She worked, had a job here. That's certainly a lot more than just a stopover to get married.
That it is, that's correct. My argument on that is that merely because they were married, merely the
But
marriage.
that alone doesn't,
That alone does not do anything. That is primarily what is argued by Mr. McAllister in this matter, is that because they were married here, that is a civil contract sufficient to grant personal jurisdiction over all matters regarding property division. And yes,
and
there
are you aware of anything, any cases that say merely that the passage of time is the indicator as to jurisdiction? That if, what if they'd only been away for 2 years, or what if they'd been away for 30 years? Are there, what's your best case that the passage of time is going to deprive Kansas of jurisdiction?
I have not found a case either way saying yes or no. And it's simply that the Kansas statute does specifically provide that a Kansas court does have jurisdiction if the parties move, or if the parties had a marital domicile in the state of Kansas and one party moves out of
At the time of the divorce, right?
At the time of the divorce, but then one party continues their domicile in the state of Kansas. There are allegations that that Mr. McAllister continued to have some contact with the state of Kansas. Frankly, there are a number of cases that indicate that merely making an allegation that there is contact or is a continuing domicile in the state does not mean that there is. There has to be more than that. And as we indicated, and as admitted by Mr. McAllister's counsel, there were no filings of income taxes in the state of Kansas or in the United States for a significant number of years. There was no driver's license. Judge Hobber did find that Mr. McAllister reestablished his residence in the state of Kansas sufficient to grant the divorce, but reestablishment doesn't then mean that it jumps all the way back to when these parties lived in the state of Kansas together.
Thank you. Any other questions in the panel?
Yeah, just to follow up on the last observation you made. And again, this is not my area of expertise, but the way I read the statutes and looking at this, if there is no personal jurisdiction, just assuming that, and a party wants a divorce in Kansas, the party seeking the divorce can obtain in rem jurisdiction to dissolve the marriage and then dispose of any property within the state. Is that correct?
That is correct.
And but that requires service by publication.
Well,
right?
Not necessarily by publication. It requires some kind of service, whether that be by publication, certified mail. There can be any kind of service and process on the out-of-state party, wherever that party may be out of state. And that would be sufficient notice of the fact that there is a filing of a divorce and that the court can exercise in rem jurisdiction over the property that exists within the state.
So I'm sorry, go ahead.
Well, does this, we may be getting a little off on a tangent here at this point, but the service of process on the individual who's the other party in the divorce, even if there's no personal jurisdiction, does it have to be sufficient service under the law?
It has to be, well, it has to be sufficient service, whatever that is under the facts of the case. In many cases where there is publication service because the petitioner does not know where the respondent is living.
Right.
And in that situation, the party can obtain the divorce and can obtain a decree dividing the property that exists in the state. In a lot of situations, there will be certified mail service or personal service or residential service at the location of the party living outside the state. And then the divorce decree can be entered and the property within the state can be divided.
Mr. Nelson, one last question from me. So are you saying that Judge Hauber could grant the divorce, that the granting of the divorce is not the issue, that if there was sufficient service, he can grant the divorce, he just can't dispose of any property outside of Kansas. He can't order the disposition of any property outside of Kansas.
That's correct. And in addition to that, he could not, for example, dispose of property that doesn't have an existence within the state, such as
Right, bank accounts.
Such as bank accounts and such.
Okay, so you can get a divorce. He can get the divorce even though the court found there was no personal jurisdiction over her.
Absolutely.
Okay. And that's, and what do you have, I mean, upon what is that based? Again, I'm like Judge Atchison, this is not was never my area of expertise, so.
What the courts, including the U.S. Supreme Court, have determined is that the dissolution of a marriage, or you're dealing with the rem, the marriage is the rem.
The marriage is in rem?
The marriage is in rem. All you need in order to grant a divorce is jurisdiction over one party.
And you say in this case, I've looked at Judge Hauber's order. In your motion, you sought a determination that the court lacked subject matter and personal jurisdiction, and you were not granted subject matter. So Judge Hauber still maintains part jurisdiction.
He does. We argued that Mr. McAllister had not resided in the state of Kansas for sufficient time. He had not lived here for 60 days, sufficient to grant subject matter jurisdiction for his filing of the divorce. Judge Hauber decided that Mr. McAllister had resided in the state of Kansas for more than 60 days, and so he could grant the divorce. But Mr. McAllister did not then seek the divorce, and that's the nature of this not being a final judgment.
Okay, say that again. I didn't hear that. But Mr. McAllister did not seek a divorce?
He did not obtain a divorce decree. He filed his petition for a divorce. He obtained a default divorce decree. Judge Hauber set aside that decree, and Mr. McAllister then filed this appeal instead of going ahead and getting a divorce.
Which then Mr. McAllister could appeal both decisions to this court. Could then appeal the personal jurisdiction issue.
Yes.
Is what you're saying.
Yes.
All right, any other questions of Mr. Nelson? Okay, Mr. Odle, you've got 5 minutes.
Your Honor, I think one central issue here that we haven't touched on yet is how you construe the long arm statute alongside 60. Gosh, I can't see anything anymore. Sorry. Under 23-2501, which says in plain language, as plainly as you could say, a marriage is a civil contract. What does that mean if it doesn't fall then within the provisions of the long arm statute and the contract prong?
Okay, let me, I'm sorry, Mr. Odle, let me interrupt you one more time because I want to get back to this question of, you do family law all the time too?
I'm a sports lawyer, actually.
You're what?
I'm a sports lawyer, actually.
Oh, okay, so you've gotten thrown into this too. So what is your position as to whether or not Judge Hauber even if we assume that Mr. Nelson is right and there was no personal jurisdiction, does Judge Hauber still have the ability to grant the divorce? It's just a matter of the property distribution.
I think that's correct, Conrad. I think that the court had.
Well, wouldn't that be even more of a reason to say we don't have jurisdiction then, if there's still an order that the judge could enter based on his order here, simply setting aside the default? He could still come in and grant the divorce.
I respectfully disagree, I think, because one, my client did not seek that specific remedy, and two, he could have ordered it, but did not. So in the order,
Your client didn't seek a divorce? His petition wasn't a petition for divorce?
He didn't seek dissolution alone. He also sought, property division, division of the marital estate, not maintenance, but beyond simply a dissolution of the marriage. So, and the judge, if could have very easily, left intact the portion of the judgment. I mean, I think we all know that a decree or a judgment in a divorce case is subject to the rule of divisible finality. So he could have, any party can appeal any aspect of the case. For example, if the court grants the dissolution, but divides the marital estate in a way that one or the other parties disagrees with, that's a final appealable order. And even though other proceedings go forward or could go forward, it doesn't change the fact that that's a final appealable order. I would also note that I don't think Mr. Nelson disputes that any of the prongs of the long-arm statute, they're not mutually exclusive. So more than one can apply, including transacting business. And we cite cases in our brief where the court has evaluated or entertained the argument that each of the other potential prongs, such as transacting business, could apply. But in those particular cases, found that they were not sufficient contacts. Here again, I think the trial court erred by simply disregarding what are clearly minimum contacts, simply because they were occurred in the early 2000s before Mr. McAllister was transferred. And there just is no law that supports that. As we cite in our brief, federal cases discussing this issue in the context of Rule 60B make it very clear that the staleness or timeliness of the contacts is pertinent only to the question of general jurisdiction, not specific jurisdiction. Because otherwise, calling Kansas a single act state would mean nothing. It either is or it isn't. And I guess the other item I would mention is that by construing Section H, which I think Mr. Nelson just conceded was now advisory in light of the 2010 amendment, the court is strictly construing it to only apply where one spouse is continuing to reside. And I don't think that eliminates the application of subsection L, and especially where, as here, there are minimum contacts. And in terms of, I guess it's subsection H, the marriage prong, I think that's even questionable now after Bristol Myers Squibb and Walden v. Ferrari, because the Supreme Court made clear that the court needs to focus on the defendant's contacts with the forum and not the plaintiff's. So it sort of stands that principle on its head to say that there's only personal.
Which case stands it on its head? I didn't hear.
Oh, Walden v. Ferrari.
Ferrari.
And the Bristol Myers Squibb case, they're cited in our brief.
Right.
But
I just didn't hear what you said. Okay, go ahead.
I apologize. But I think they made very clear that if you focus on the defendant's contacts with a foreign state, the plaintiffs virtually don't matter as a matter of due process. And that's the U.S. Supreme Court's holding. So in that regard, whether Mr. McAllister intended to abandon his domicile in Kansas or not really shouldn't even matter. And certainly when you collapse all the prongs of long-arm statute into the due process inquiry, I think you find that there are sufficient minimum contacts by entering into a contract of marriage within the state of Kansas, living here for a number of years. And I don't think it matters that or should matter that it was 10 years, 5 years, 15 years. And with that, I'll stand on our brief.
Thank you. Any other questions from the panel? Okay, thank you very much, gentlemen. We've appreciated your argument. We will take the matter under advisement and get a decision out as quickly as possible. But thank you for answering our questions.